Joined now in our studio by Minneapolis criminal defense attorney Joe Tamburino. Anything unusual?
Well, we learned three important items. No issue as to his mental state, no issue as to change of venue, and no issue as to bail. You heard the judge ask his own attorney, do you understand about waiving your right to have what's called a speedy preliminary hearing, which is usually done within 20 days. No problem with that. You heard about the issue of the bail, $5 million. No issue there. They didn't argue against it. And also importantly, they didn't say anything about a change of venue motion. So we learned three very important things just in this brief appearance.
Does the change of venue surprise you, not asking for it?
No, not in today's world, because as you know, with the web, with all media, it's almost impossible that if you even did get a change of venue that you could keep certain cases away from the press. It's almost impossible.
Did the lack of bringing up anything about his mental state surprise you?
It did in a way, because really the only defense that you could ever have, and again, we don't know much about this case except what's in the complaint, is some type of mental illness. But it's clear just based on the way he looked. I mean, it looked like he was of sound mind. He was able to waive his preliminary hearings timeline. He was obviously communicating with his attorney. So just on this brief period of time in this first appearance, the initial appearance, the mental state seems to be fine.
Yeah, we heard him say yes, sir, initially. When he asked his name, we heard him say yes, sir, if he wants to waive the preliminary exam and the time limits, and we heard him say no to another question, and that was about it. And a couple times he was kind of stroking his face. For those of us not familiar with the legal world, what is that preliminary examination, and what does it mean to waive the time rights? What are those two things, Joe?
Well, almost everyone does waive the time rights, because what happens is you want some period of time to prepare. At a preliminary hearing, a judge has to determine if there's probable cause to go on with the case. Hearsay evidence, meaning that you could have one officer testify about what the case is about, is totally admissible. Many people waive the preliminary hearing. I suspect in this case they just want some time so that they can talk with their client and try to determine what to do in the future. But the preliminary hearing, I don't think is going to be a major deal in this case, because I think the judge is going to find probable cause.
Okay. So preliminary hearing, preliminary examination, those are the same thing?
Correct.
Okay, so they'll be back in court on February 6th.
Correct.
Also, we'll keep talking to Joe, but just to let you know, we're going to stay on the air because we're expecting the Barron County District Attorney to speak very quickly and hold a press conference. We want to hear what he says, and we want to get to some questions with him as well. On the charges themselves, for someone who's just joined us, Joe, 2 murder, 1 kidnapping, 1 armed robbery. The homicides are first degree. What's that mean in context of Wisconsin law?
Life in prison. That's what it means, just like in Minnesota. In Wisconsin, as in Minnesota, there's no death penalty. So if you do get convicted of something like a first degree murder, premeditated murder, anything along those lines, it's going to be life in prison. And that's what this would call for. In fact, there would be 2 life in prison sentences.
Yeah, followed by the kidnapping, the armed robbery. And there is no death penalty in Wisconsin, just
Correct.
I think people remember that. The 3 things, bring those up again, because the change of venue you said didn't, but
Sure.
the mental state, you seem a little surprised by that?
Yes, only because that's really the only avenue that you're going to have as a defense. Now, obviously, there probably isn't any evidence of that. We don't know that, but from what we could read in the complaint and that initial appearance. I mean, the judge specifically asked his attorney, which is common, does your client make a knowing, intelligent waiver of his right to have a time period, a speedy time period before the preliminary hearing? He said yes.
Yeah.
And as you could see, it looked like the defendant was able to understand the judge's questions, answer them clearly. It didn't appear to have any type of defect of mental reason.
All right. We're in studio right now with Minneapolis attorney Joe Tamburino, and get his thoughts on what we just saw. So, Joe, unpack some of that. What were your takeaways?
Well, 3 things. Number 1 is that the district attorney's office is not going to be discussing this case outside of what's already in the complaint. That doesn't surprise me. That's a very professional office, and they don't want to jeopardize an ongoing investigation, because right now, we can only assume that there's still a lot of matters that's being investigated.
Sure.
Second, that there have been no motions so far for any type of change of venue. He even stated that. There was a couple of questions to him about that. And third, he was asked about whether or not Jamie would be a witness in this case. Now, it's very early on to say what would happen at trial. She certainly would not be a witness at the preliminary hearing. At the eventual trial, in many ways, she doesn't have to testify.
Yeah, I was taking back that too when they asked about that. He said his intention right now is they don't want her on the stand.
Right.
But they might have to change their strategy later.
Sure, they could, but at least with the 2 murder charges, in murder cases, many times you're not going to have an eyewitness, and you don't need an eyewitness because you have all the other information, the scientific, forensic, and in this case, the confession that we see in the complaint.
I was also taking, Joe, like you were on a couple of your points. You know, number one, I mean, he basically said we're not going to give out a lot of information. And I'll take a step back. Barron, Wisconsin, the town that she was found in, is also the name of the county. So Barron, the town of Barron, is the county seat of Barron County, Wisconsin. So everything's going to be happening in Barron. That's where the courtroom is. That's where the sheriff's office is. Just to make that clear, and Douglas County is where she was found. Yeah, he's not going to. The reporter's questions were excellent, and there were a lot of them. And most of them, he said, I refer you to this 12-page complaint.
That's right.
That he's not going to talk a lot about these. But when he went to motive, he was asked about motive twice. Once about halfway through, and once the other about towards the end. And he said, I'm going to let this kind of speak for itself, but more information is coming. What's more information in your experience? What would we expect to see?
If they actually have a preliminary hearing where they're going to have an investigator, a law enforcement official testify, and the defense will be allowed to cross-examine him, you would have more information come out. Okay. But mind you, in many of these situations, the preliminary hearing is set but then waived. We're not going to know until February 6th that they actually will have a hearing.
And with the confession, with the complaint, with all the evidence, with the charges, do you think this goes to trial? I mean, he kind of expected it would.
Well, the only reason that it would go to trial is because they're not going to offer any plea bargains in this case. There is no way that you're going to get somebody to say, look, we'll plea to a lesser charge. That's not going to happen. So really, it would be only because there really are no other alternatives but to do a trial. So maybe that's why he's thinking there could be a trial.
Okay. Joe, we appreciate you being here today. Great insight as usual.
Thank you.